Hey everybody, I'm back! I hope all of you had a great holiday, a little bit of rest, a little relaxation. If you are of age, a few sparkly, bubbly beverages. Today, before we even get into the case that we're going to be talking about, I just want to say a really big thank you. We have not only hit our first 100 subscribers, we blew right past it, and we're at something like 119, 120 when I'm recording this video. So if you're one of those, thank you so much. I can't tell you how much I appreciate the fact that you have subscribed and that you come back. We've had some really good discussions on the comment sections and the cases, so that's always great to see too. And if you're new to the video, hello, welcome to the party. I hope you enjoy. For today's video, we're going to be moving away from my usual discussions of civil procedure, constitutional law, criminal law, and we're going to pop over into the land of torts and go up to Alaska for a defamation case. And it's going to be MacDonald v. Riggs. Now, this particular case is started back in the early 2000s. There's a city in Alaska called Tenakee Springs. If you know the town and I'm mispronouncing it, apologies, let me know down in the comments. What they ended up doing is they passed an ordinance that prohibited the use of motorized vehicles in certain areas around town. Now, this set off a rather odd conversation and debate about a motorized wheelbarrow. There's a woman and her name was Judy MacDonald. At the time, she was 64 years old, and she was using this motorized wheelbarrow to haul groceries and supplies around on a road that provided only access to her own property from a nearby boat landing. In relation to this use, in 2001, the city created a legal research committee, big air quotes here, to investigate the legality of the use of this particular wheelbarrow as well as other instruments on the road, and appointed her neighbor, Merle Wilson, the chair of this particular committee. A little bit of editorializing here, but Wilson apparently took it upon himself to personally impound the wheelbarrow, assaulted Ms. MacDonald at the time, hitting her with either a piece of logging chain or the metal end of a dog leash. Apparently, he also attempted a citizen's arrest because MacDonald attempted to assault him and took her to his house. Now comes Riggs, who's the named individual in this particular case. It was disputed in the case as to just what Riggs had to do with this whole hoopty-law. MacDonald said that Riggs was her ex-boyfriend, and she said that he threatened her with a rifle and helped Wilson to forcibly bring her to his house. Riggs and MacDonald disputed that and said that Riggs hadn't shown up until after the assault and was unarmed when he did so. So a lovely version of he said, she said, which is always so much fun to have to deal with. After this particular altercation, MacDonald left the house or was released, or it wasn't very clear in the case law, but she went from Wilson's house to a neighbor, and at the neighbor's house she was able to get some medical attention and had ended up being diagnosed at a hospital with a skull fracture and had to actually be flown to Seattle for additional treatment. Wilson gets arrested. He pleads something called nolo contendere. You probably have heard it as no contest, and as a result, he was given 6 months in jail, 4 years of probation. Riggs wasn't charged, but then the city of Tenakee Springs sued MacDonald to enjoin her, to stop her from using the wheelbarrow. Now, this particular suit was settled in MacDonald's favor, so she got to keep using the wheelbarrow, and she also got a protective order placed against Riggs. Now come the lawsuits. MacDonald sued both Wilson and Riggs on a whole host of allegations, things including assault and false imprisonment. Riggs countersued for defamation. Now, Wilson lost immediately. He had pled no contest, which basically means, yes, I did it. I'm not going to contest the charges. So he lost the lawsuit immediately and was hit with summary judgment by the judge. Now, MacDonald got over $200,000 on that particular finding. The jury then found for Riggs and awarded him $35,000 from MacDonald for the defamation. And we get to the case we're talking about today because she appealed on something called the denial, her JNOV, which stands for judgment notwithstanding the verdict. And it's just a quick bit of background to understand what that is. It's basically where a judge that's overseeing a civil jury trial has the ability to overrule the decision of the jury and reverse or amend their verdict. Basically, the judge is saying, there's no way you should have or could have come to the result you did. I'm going to get rid of it and implement my own judgment. So by the time the court gets their hands on this particular case, on the appeal, they start out their discussion by looking at the JNOV and the standards that are associated with it. Now, MacDonald had made arguments that there were no unprivileged defamatory statements, but even if there were, they were barred by statutes of limitations, and she said that Riggs hadn't bothered showing evidence of any actual harm, which quite often is a requirement of defamation. And looking then to Alaska's defamation statute, the court found that it actually has 4 elements. 1, a false and defamatory statement was made. 2, an unprivileged publication to a third party. 3, fault amounting at least to negligence on the part of the publisher, who's the person saying it. And 4, the existence of either per se actionability or special harm. There's also an extra little bit that it's necessary that the recipient of the defamatory communication understand it as intended to refer to the plaintiff. It's all about you. So considering these particular requirements for defamation, the court reviewed the record that it had at hand and found that there was evidence that MacDonald had made unprivileged statements to a third party after the assault, which could have been considered defamatory. In the light most favorable to Riggs, which is the standard for the JNOV, a reasonable juror could conclude that MacDonald had made the statements at issue, including that Riggs had been armed and assaulted her. So then the court applied again the definition against the facts in this particular case and said that basically accusing someone of holding a woman at gunpoint in the aftermath of what sounded like a fairly vicious assault would indeed be defamatory under the definition. And because she made these statements outside of the courtroom to begin with, as in the house, at the hospital, outside of a privileged, protected environment or relationship, there's no privilege that can attach to those statements to protect her against the lawsuit. So having dispensed of the no unprivileged statements argument that she made, the court turns to the second argument, that even if there were evidence of defamation, the statute of limitation would bar the lawsuit. So in terms of timelines, the lawsuit was filed on March 21st, 2003. He answered the lawsuit on April 15th, 2003. So, with a 2-year statute of limitations, MacDonald was attempting to argue that he was barred from suing on any statements that she may have made prior to April 15th, 2001, 2 years prior to the date he answered the lawsuit. Now, everything that was being debated and occurred happened on April 2nd, 2001. This leads to a fairly significant discussion in the case of Alaska's civil procedure on statute of limitations. I'm not going to go into it for purposes of this video, but if you are a civil procedure wonk, if you like all the nitty-gritty, I do recommend you go and look into it. They go through a pretty nice analysis of that particular statute. But on the review, they found that his counterclaim was valid in terms of the timing. Basically, they end up finding that the statute of limitations in Alaska does not bar his counterclaim. And now we get to slander per se, which is going to be different than the defamation or slander more generally. Now, slander per se or defamation per se, depending on your jurisdiction, basically means that as a matter of course, if you say these things, it is considered defamation. It is considered slander. Now, in many jurisdictions, this is going to include making allegations that would impute a serious crime to the plaintiff. In Virginia, for a while, if not currently, I would have to go back and check the statute. It used to be imputing inchastity to a woman was defamation per se. Now, Riggs' use of the rifle, as she alleged in this scenario, is just such a crime, right? She's alleging that Riggs, armed, assisted in the involuntary detention and assault of her. That's a crime. That's a crime that will normally get you thrown in prison for a little while, and as such, it would generally qualify as a per se defamation. As a result of that, the jury is allowed to award general damages rather than specific damages for a specific harm for the purpose of compensating the plaintiff for the harm that the publication has caused to his reputation. Normally speaking, in defamation, you have to be able to show an actual harm, as in, I can point to the job that I lost and the amount of money that I lost, or the contract that I didn't get, or the contract that was canceled. There's something specific that I can point to with a dollar amount that I can say, this is my harm, pay me back. For per se, they will award just general damages, and that's usually tied more to reputational damage destruction. The court found that she made these statements in a small town, which involved serious allegations, and a reasonable juror could find that the statements had an impairment of reputation and standing in his community, personal humiliation, mental anguish and suffering. As a result, the court noted that the lower court had required actual harm to be shown when they did their analysis, which this court found wasn't necessary because it was a slander per se, so that part was an error. But the error was to MacDonald's benefit. There was no impact to her substantial rights, and as a result, the JNOV was actually properly denied. Because remember, we're on appeal saying that from MacDonald's point of view, her JNOV was improperly denied. This court is saying, no, actually, the error committed by the lower court helped you, and it shouldn't have. And because it didn't affect your substantial rights, it was to your benefit, you weren't impacted, the JNOV is actually properly denied. So Riggs was able to keep his $35,000 defamation award. So that was MacDonald v. Riggs. I hope you enjoyed the case. Defamation's one of those things that's exceedingly odd, and usually I find it quite frustrating to apply. But once you get a good set of facts, it actually makes it much easier conceptually. So let me know what you thought down in the comments below. Particularly, what do you think about the idea of defamation per se? Let me know in the comments below. But until we are together again, stay safe, everybody, and I hope you're well.